If somebody wants to increase their emotional competence, what's the way to do it?
The easiest and fastest way to develop your emotional competency is to learn how to listen to and reflect emotions. It's a skill called affect labeling, A-F-F-E-C-T labeling. And basically, it's a three-step process. When you're a listener, and let's suppose that, Parag, you're upset. I'm going to do three things. The first thing I'm going to do is ignore everything that you say. I'm just going to completely ignore your words. The second thing I'm going to do is I'm going to sit in silence for a moment and let another part of my brain, an innate part of my brain, read what's going on and basically read your emotions, which my brain can do and your brain can do automatically, effortlessly, and supremely accurately when we allow ourselves to do it. And then the third thing I'm going to do, as the emotions start to come into my consciousness, I'm going to reflect back to you what you are experiencing with a you statement, not an I statement.
Welcome back, everyone, to the From Crisis to Justice podcast. I'm your host, Parag Amin. Today, I'm joined by a very special guest, Doug Noll. Doug is a former trial lawyer turned mediator and executive coach. He's also a best-selling author who's written 4 books, including his most recent book, De-Escalate. Welcome, Doug. Thank you so much for being on today.
Parag, it's always fun to be in a conversation with a former like-minded soul, a business litigator.
Yeah, I love it. Yeah. So, all right. So let's talk about this. You went from business litigation, trial lawyer, and if you would just give our readers or listeners a sense of what that life is like, and then now turning into a mediator, an executive coach, and a peacemaker, as you described yourself.
So we start at the beginning. I grew up in Southern California, where you live now. I grew up in San Marino, which is just outside of Pasadena, California, in the San Gabriel Valley. When I graduated from high school, I went back to Dartmouth College. Graduated in Dartmouth, came back to California, taught skiing for a year, and then entered law school up in Sacramento in 1974. Graduated from law school. I was on the law review, did well. So I took a judicial clerkship. I didn't want to go back to LA and I didn't want to go to the Bay Area. I wanted to live near the mountains. So I took a clerkship with the 5th District Court of Appeals with Justice George Hopper and worked in Fresno for a year and then ended up staying here and joining a mid-size firm that was a litigation bankruptcy firm. So they did all kinds of litigation plus bankruptcy. And that was in September of 1978. I tried my first jury trial 6 weeks later in October of 78, 3-day jury trial in Madera County. And then my next jury trial started in December of 78, defending a $36 million securities fraud case in the Southern District of California in San Diego, and spent 7 months in San Diego defending a Kern County farmer who had been accused of securities fraud by a bunch of securities investors. And we successfully defended that and went on our cross complaint. And that's how my career as a trial lawyer started. Along the way, I'll say maybe 10 years later in the 86, 87, I took up the martial arts and was awarded my second degree black belt when I turned around my 40th birthday in 1990. And my teacher told me, go study Tai Chi as a martial art. No more Chinese Kung Fu for you. Too arrogant, kind of an asshole. You're going to hurt somebody. So I started studying Tai Chi, and Tai Chi has 2 really interesting paradoxes. The first is the softer you are, the stronger you are, the more vulnerable you are, the more powerful you are. Soft to be strong, vulnerable to be powerful. Did not compute. And as you can well imagine. But I continued to practice until it did finally seep into my soul. I didn't know this, but I was in a courtroom trying a case in 1997, I think, maybe it was 96. And the thought came to me, what the heck am I doing in here? So after that trial, I had a whitewater trip planned up in Idaho with a bunch of friends and spent a week on the main salmon in my raft, thinking about how many people I'd really served as a trial lawyer. And I could only count 5 people in 20 years that I felt had come out of the system better than going in, that I had represented. And I thought to myself, I've been doing this for 20 years. I don't want to do this for another 30 years and say I've only served 15 or 20 people. There's got to be something better. So I knew I didn't want to be a trial lawyer anymore, but not knowing what I was going to do, I came back town and drove out of the mountains to my office after the Monday after that trip. And the universe provided. I heard the one and only public service announcement on our local public radio station for a new master's degree in peacemaking and conflict studies being offered at Fresno Pacific University, which is one of the West Coast Mennonite universities. And for those that don't know, the Mennonites are one of the three traditional Protestant peace churches. I'm not a Mennonite, not a churchgoer, but I ultimately enrolled. And my teachers, my mentors completely changed my worldview. So it took me 3 years to get through that program. So I was for in the late 90s and up until about 2000, 2001, I was a full-time master's degree student, a full-time trial lawyer, and a 3/4 time law professor at our local law school. So life was a little crazy in those days. I ultimately graduated, and I had been having a lot of discussions with my partners about a career, what I want to do. I said, I don't want to try cases anymore. I want to help people solve problems, before they get into the courtroom. And they were not happy about that because I was the second highest earner in the firm, and they were looking at the goose that lays the golden egg, not laying golden eggs anymore. Finally, the managing partner gave me an ultimatum on a Friday in 2000, in late October, said, quit this peacemaking crap or we're not paying you anymore. So I went home and talked it over with my wife, and we did the numbers, and I came back Monday morning and I grabbed him and went into our firm manager's office, and I took out my credit card, my keys, my cell phone, all this stuff. And I said, I quit. I'll be gone on Friday. And that's the amount of notice I gave. And then the following Monday, which was November 1st, 2000, I opened up my peacemaking and mediation practice. And that's how it started.
Wow, that's incredible.
Left $10 million on the table.
For your partnership or
I left $10 million. I put in $10 million more into the partnership than I'd taken out. I walked away from it.
Wow. So you felt that strongly about this?
I did. The money
didn't matter. Do you regret it now? Do you regret it?
Not at all. It was the best decision I've ever made in my life. I've done more good in the last 25 years. I do more good in a week than I did in 22 years as a trial lawyer. I helped more people in a week than I helped in 22 years as a trial lawyer. My life is just one blessing after another. And I've done some amazing things that we can talk about.
Yeah, that's great. I mean, let's talk about them. So part of your book and part of, I think, a big philosophy of the things you talk about is emotional competence.
Right.
So can you talk a little bit about that? Because that's not a subject that I think hardly anybody really has studied deeply.
Right. So as I was studying about human conflict and how peace works and doesn't work, this is in my master's degree, I got through a series of events. I was connected to Professor John Allman at Caltech there in Southern California. And John was a neuroscientist and sort of schooled me in how to understand neuroscience as a layperson. Because I came to the insight that all conflict starts in the brain. And peace has to start in the human brain too. That's where it all begins. So if we can understand how our brain functions, maybe we can get some insight into how to stop people from fighting, or if they are fighting, how to help them find peace. So that's where it all started. The one thing I did not get out of my graduate studies is how to calm angry people down. There were lots of people out there teaching stuff like active listening and nonviolent communication, but none of that stuff worked for de-escalating really angry people. And I was kind of at a loss as to what to do, but I had been studying emotions. And one day in 2005, I was engaged in a pro bono difficult mediation in Santa Barbara involving a divorced couple. And to make a fairly long story short, when we started the mediation, had there been knives on the table, there would have been blood on the floor. I mean, they hated each other's guts, and they were screaming vile obscenities at each other. I didn't know what to do. I had the thought, listen to the emotions. So instead of having them talk about their stories, I had them, one person tell the story and the other person reflect back what that person was feeling. And it was magical. In 3 hours, they completely calmed down. They settled the case. I wasn't involved in that negotiation at all. They just realized how ridiculous it was. They settled the case and they walked out to have lunch holding hands. And they had been divorced for 20 years. It kind of blew me away. My jaw hit the floor. And I knew what I'd done, but I didn't know why it worked. 2 years later, a brain scanning study came out of Matthew Lieberman's lab at UCLA showing why this technique called affect labeling worked. And it turns out that our brains are hardwired, that when we are upset, we lose control because our prefrontal cortex is overwhelmed and shut down. Everybody's pretty much aware of that. But this technique of affect labeling reactivates a part of the brain called the right ventrolateral prefrontal cortex, and at the same time inhibits the emotional centers of the brain. It's an automatic de-escalation that occurs in every single human brain, no matter where you live on the planet. Every human brain is hardwired this way. So now I have the science to support the practice, and so I started developing the practice. And the more I got into this, the more I realized that human conflict is caused mostly by people who do not know how to manage their own emotions. They're essentially emotionally incompetent. Then I started looking at emotional intelligence. And what I learned was that emotional intelligence was a term coined in the late 1980s by John Mayer and Jack Salovey. One at the University of New Hampshire, the other one is now the president of Yale University. And they began to publish papers on their study of social intelligence, other than cognitive intelligence, which is measured by the Stanford Binet IQ test. Daniel Goleman, as most people know, was a PhD, but he was a New York Times science writer. He picked up on their work and wrote a best-selling book in 1995 saying why EQ is more important than IQ. And that he sort of popularized the idea of emotional intelligence. But the problem was, as I studied the academic literature, was that emotional intelligence cannot be learned. It can only be measured. And so all these companies out there tout, I teach emotional intelligence. Anybody that says they teach emotional intelligence doesn't know what they're talking about, because you cannot learn emotional intelligence. What you can learn is emotional competency. And emotional competency has three foundational skills. Number one, we learn how to become self-aware of our own emotional experience. Number two, we learn how to regulate our emotions. And number three, we learn cognitive empathy. And what I learned as I started teaching these skills and teaching people how to de-escalate, and then into the prison project, which we can talk about, as I taught thousands and thousands and thousands of people these skills, what I saw was when they learned how to listen to and reflect emotions, which is cognitive empathy, they automatically increased their emotional self-awareness and their emotional self-regulation, and their emotional intelligence just naturally increased. So today I talk about emotional competency and learning how to increase your emotional competency, and as a result of that, your emotional intelligence rises. But if you try to learn emotional intelligence, you will fail.
Okay. So if somebody wants to increase their emotional competence, what's the way to do it?
The easiest and fastest way to develop your emotional competency is to learn how to listen to and reflect emotions. It's a skill called affect labeling, AFFECT labeling. And basically it's a three-step process. When you're a listener, and let's suppose that, Parag, you're upset. I'm going to do three things. The first thing I'm going to do is ignore everything that you say. I'm just going to completely ignore your words. The second thing I'm going to do is I'm going to sit in silence for a moment and let another part of my brain, an innate part of my brain, read what's going on and basically read your emotions, which my brain can do and your brain can do automatically, effortlessly, and supremely accurately when we allow ourselves to do it. And then the third thing I'm going to do, as the emotions start to come into my consciousness, I'm going to reflect back to you what you are experiencing with a you statement, not an I statement. So that old active listening stuff doesn't work. So I would say something like this. So Parag, man, you are really pissed off. You're frustrated. You're angry. You feel completely disrespected. You feel invisible. And you don't feel heard or supported. and this is really making you anxious. So just by saying that, and you can actually go 3 or 4 levels deeper than that, but just by me telling you what you're feeling, your brain immediately calms down. You can't help yourself. It's automatic. And once you start calming down, I'm looking for 4 relaxation responses: nodding of the head, a verbal response, yeah, or exactly, and then below that, a dropping of the shoulders and a sigh of relief. When I see those 4 autonomic relaxation responses, then I know I've succeeded in calming you down. And I say, so how do you want to solve this problem? How should we solve this problem? So I can move into negotiation. I can move into problem solving. If there's offense involved, I can say, how do we make things right? So the next question invites a conversation about what caused the emotional reactivity in the first place. And that's basically how we do it. It's easy to describe, like everything else. It's simple to describe. Not so easy to put into practice. It takes a little bit of effort to practice it because the skills are counterintuitive and counternormative to everything we think we know about listening and conversation.
Yeah, I love that. It's interesting because I have intuitively used a somewhat similar technique when dealing with emotionally charged situations, as you know, in our business of
That's right. Emotionally
litigation.
Charged. It can be business,
Highly.
But it is still emotional as it can possibly be.
Right. And so usually what I found highly effective with opposing counsel is I'll just say, look, it seems like here are the issues. You're upset about this, this, and this. And I get it. Your client's fired up about this, this, and this. And I will take my own emotion out of it. But then just voice to them why they think their position is strong. And I'll use the word but, and I've heard mixed things about using the word but. Usually it's don't use but because people will disregard everything you said before the but and instead switch it out with and. I just did it there. But what I'll do is then I'll say, but here's why I think this makes sense, or here's how we can potentially resolve it. So I'm curious to hear your feedback on that.
So you're close. So if you've got counsel who's really upset about something, it could be a discovery matter, or that's usually what people get upset about, or usually it's discovery or some kind of law in motion problem. You say, hey, Parag, you're really pissed off. You're really angry and frustrated. You feel completely disrespected, and you feel like you're being ignored and not being heard. And you're really concerned about your client and your client's interests, and you just think what's going on here is outrageous. And I wait until I get the yeah, exactly. And I'll say, and the whole thing is just super frustrating to you because you don't feel like you've got a lot of control over the situation. Notice how I'm using a lot of yous. I'm not using any I statements. I'm going to keep it going in that vein and just let you talk and me reflect your emotional experience until I get, yeah, exactly. Okay, anything else? No, you got it. All right, Parag, how do you think we ought to solve this problem? So I'm only labeling your emotional experience and inviting you to keep talking, and I'll just keep labeling your emotions until you get quieted down. And then I'm going to invite us to collaborate in a conversation or a negotiation around how we're going to solve the problem. Until you get your opposing counsel calm down, you're going to butt heads.
Mm-hmm.
You in court. And now all of a sudden you got a, $15,000, $20,000 motion that you got to face, and it gets nowhere because the judge hates these things and is going to tell everybody to go outside and figure it out. But you've already spent the $25,000 on the briefing, and it's a complete and total waste of money, and that's why litigation is so expensive. But
right,
you can short circuit all of that if you take the time to listen to opposing counsel, validate their emotions, recognize that everybody's emotional. Lawyers are just as emotional as everybody else. Validate their emotions, calm them down, and then invite them into a collaborative problem-solving process.
Yeah, I love that. So, and I agree with you. That's one of the reasons why I found this rudimentary approach that I've just kind of self-developed and I'm now refining through this conversation with you to be helpful. Is a lot of times I have found that it helps create a lot of efficiency out of inefficiencies that are built into the litigation system,
Right.
ultimately assisting the clients, because the lawyers fighting with each other just creates more time, more expense for the clients needlessly.
That's right.
When a lot of these things can be resolved through, like you're talking about, with the emotional competence to be able to deal with the situation. Now, let me ask you this. When the other side makes a request, when you say, look, how do we move forward from here? And the request is something you completely disagree with. So in this example, we're talking about us being opposing counsel. You have asked me, hey, how do we resolve this? And I say something like, well, Doug, your client can just wire transfer my client $2 million. We'll call it even, and we'll dismiss the case. How do you deal with that if your client's not ready to wire transfer that money?
I would say, so Parag, describe for me exactly why it is that you don't think there's a defense to this case. Tell me why I should advise my client to do this.
Mm-hmm.
What am I missing here? If you can convince me that 9 times out of 10 we walk into court, we're gonna lose our ass, then I will tell my client to wire transfer you $2 million. But your job is to tell me where are the flaws in my defense.
Okay, I like it. Now, let's say that the other side is guarded about some level of information, as they will be in litigation. Can't tell you everything, Doug. You're just going to have to figure it out. In any other situation, the person's still potentially upset or a little scared to be vulnerable, like you were talking about at the beginning of our conversation.
So, Parag,
so how do you get past that?
So, Parag, I completely get it that you're guarded and you don't want to give free discovery. But just understand, without the information that I'm asking for, without your showing me where I'm wrong, my only alternative is telling my client to defend this case and not pay you the $2 million. And there's no reason for us to get upset about it. You've got to protect your interests, and you can completely understand that without a compelling reason, I can't advise my client to do what you want. So let's just litigate this thing and not get upset about it.
Mm-hmm. Yeah, I like that. Yeah, I mean, it sounds like it's a label. You still go back to the label to see if that spark starts a fire.
That's right. So okay. I could say, so Parag, you're really nervous and concerned about revealing information that might put you at a disadvantage and put me at an advantage over you. And so you're really worried about disclosing information that you think is important that I should consider, but could be disadvantageous to you because it's either got impeachment value or it's got some value that keeping it hidden for the time being works for you.
Mm-hmm.
And so you're unwilling to reveal that information because you don't want to give me an advantage over you, or you don't want to give up an advantage that you think you have over my client.
Mm-hmm. That's right.
So taking that into account, tell me how we should move forward with this.
I see. So you then give them the opportunity to create the solution to the problem.
And notice that there's no I statement in there.
Right. Yeah. So it's all about them.
It's all about them.
Mm-hmm. Okay. And so you just kind of keep using that iteration to get through the process.
That's right. And at some point in time, they could say, well, it's on you to figure it out. And I'll say, okay, so you feel it's on me to do the discovery work. I'm perfectly willing to do that. Let's schedule out the depositions then, and let's work out a discovery plan.
Mm-hmm.
And if this is discoverable information, I'm going to get it, and I'm fine with that. Do we really want to spend that kind of money? If you do, my client's perfectly willing to do that. However, is it possible that the process could be made more efficient if we just disclose to each other information that would otherwise be discoverable, so that we don't have to go through all the hassle of depositions and interrogatories and request to produce documents and request for admissions and all that stuff.
Right.
Well, no,
Okay,
I
so
want
let
to
me
make
ask.
this. I got to make this. I got to be tough for my client. I got to make this hard. Okay, so you need to make this hard. You need to look good for your client. And I'm curious, what's more important to your client? That you're perceived as a tough junkyard lawyer, or that we can move towards resolving this case in an efficient, cost-effective manner?
And if the answer comes back that both are important.
All right, so which one's more important?
Mm.
Because one's your reputational interest and one is a financial interest to your client. Which one's more important to you?
That's great. Yeah.
Notice how
Yeah. And you
there's
just,
no I statements. I'm not challenging anything. I'm not saying he's wrong or she's wrong. There's no ad hominem attack. I'm just engaging in a conversation.
Yeah, I've had a mentor tell me that the quality of your questions determines the quality of your answers.
Of course. And what I did, I mean, did not, the skill level that I have now is not the skill level that I had when I was trying cases back in the 70s and 80s and 90s. But I did in those days, when I worked up a case, especially if it didn't matter which side, because, in business litigation, you can be on either side, you never know. But I would work up the case and I would do a thorough background check and investigate, sometimes using a private investigator, sometimes just lots of investigate stuff. I learned never to trust my clients. They always lied to me. And, but I would work up the case. And if I saw weakness in the case and I couldn't figure out how to go to the weakness, I go to my client and say, explain to me how we're going to deal with this. And the client said, I can't. Then I said, then we need to settle, because you can't defend this. But if the client had an ironclad case or ironclad defense and had all the documentation and evidence to back it up, so I just knew there was no way we could lose this, then I would go to opposing counsel and said, I'll tell you what, I want to have a conference with you, an in-person conference. And that's, in those days we did that. And I said, I want you to come over to my office and I'm going to lay out my entire case. I'm going to show you all the evidence that I have. And I want you to tell me how I'm going to lose. And if you can show me how I'm going to lose, then we can talk about how we're going to get this resolved on some compromise basis. But if I'm not going to, if you can't convince me or show me how I'm going to lose, then we need to have another conversation. And I would do that, and it would drive counsel crazy because they couldn't do it. Because what I learned was the way you win lawsuits is to out-prepare the other side. And I would out-prepare everybody. I mean, I would literally out-prepare everybody. And so I had, my cases were iron tight. And I said, tell me tell me how I'm going to lose this case. And of course, if I had that kind of case, then that led to a mediation or a settlement discussion of one kind. If I had weakness, I would never do that. My client say, we got to settle this case.
Right. Yeah, absolutely. It's about knowing your case well enough, your client well enough to know what's best for that situation.
Exactly.
So let me ask you about listening. So I think most of us believe we know what listening is, but what do you think? What do you think makes for good listening?
Well, there are two types of listening: type 1 listening and type 2 listening. Most people engage in type 1 listening, and that means that the agenda that they have is on them. It's the listener's agenda, not the speaker's agenda. So, for example, as a lawyer, I'm listening to my client. My agenda is to listen to the client to see if the information the client is giving me is information I can, for example, compartmentalize and change into a cause of action. I'm not listening to anything else. I could care less whether or not my client is heard or not. What I'm interested in is the information that I'm going to be using to create a pleading or to create a discovery plan or to think about how to prepare for direct or cross-examination. In that classic case, as a lawyer, I'm engaging in type 1 listening. The same thing is true in ordinary conversation. Most people engage in type 1 listening. So, for example, you might be in a conversation with somebody and say, and whoever you're talking to, say, yeah, last Saturday I was able to go out and walk my dog, and we went out and went on a trail up in the mountains, and it was great. And I said, oh yeah, that's really cool. I had 2 weeks ago, I was able to do the same thing with my dog. Are we listening to each other? No. We're only talking about each of our own experiences, but not listening to the other person's experience. And that's type 1 listening. That's the kind of listening that we all engage in. There's another kind of listening called type 2 listening, which is very different. And in type 2 listening, as the listener, my agenda is to make sure that the speaker feels understood and validated from the speaker's frame of reference. It doesn't mean that I have to agree with the speaker. It just means that the speaker has to feel validated and heard. And my whole agenda is to make sure that the speaker feels heard in terms of words and meaning and emotion. And so that leads us to 3 kinds of reflective listening that would be used in type 2 listening, which is paraphrasing, core messaging, and affect labeling. When I engage in type 2 listening, my only goal is to make sure that you, the listener, feels heard. I call it listening another person into existence. And when you go through that validation process, that's the magic. Because when people feel deeply heard, they calm down, you build instant trust and loyalty, and in personal relationships, you build intimacy because they feel heard. And it's remarkable how few people have ever been deeply heard in their lifetimes. It's so rare. And yet it's so easy to do. And it's so magical when you're able to do it and give this priceless gift to somebody else and watch them almost tear up because finally somebody gets them.
Yeah, absolutely. So is saying I hear you enough, or do you think it's important to add in the paraphrasing?
If I say I hear you, am I validating what you're saying? No. What I'm saying is it's me, 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 me. That's type 1 listening. That's why you never use an I statement in type 2 listening. So in order for you to know that you're being heard, I have to reflect to you what you said and intended to mean and felt so that you deeply feel that I've heard you because I've reflected to you what you've been trying to express without saying I.
So you're saying that the whole intention is to make sure that you're heard.
That's right. And you're kind of pissed off and angry, and you feel completely disrespected and unheard. And that's really making you anxious and scared.
And you don't go into anything about how you feel about it, whether that's rational, irrational,
doesn't matter.
Nothing. Doesn't matter what you feel.
Yeah, right, because that's not
the I.
Exactly. In type 2 listening, that is not the agenda. The agenda is on you, the speaker. What I think about why you feel the way you feel, whether I think you're full of shit or not, it doesn't matter. All that matters is that you are validated. And once you're validated and your emotional center is calmed down, now we can start to have a conversation to figure out what's going on.
Sure. So, Doug, there's a listener out there who's probably thinking, look, Doug, that sounds great for somebody who's rational, but the people I'm dealing with are just crazy. I don't know that I can use this technique with people who are just entirely irrational.
The person
what would you say to that?
Whoever says that has made a fundamental flawed assumption about human nature. Here's something that most people don't get, and this always shocks lawyers when I say it. There is no such thing as rationality. Rationality is just this made-up idea that does not exist. There is no science to support the idea that rationality exists. Not one lick of science. Furthermore, there is no definition of rationality. I'll ask you, you're an educated guy like me. What does it mean to be rational?
Something that makes sense.
Something that makes sense. And so that's a subjective definition. Because what makes sense to you won't make sense to me. So give me an objective definition of rationality that we can use to objectively define what it means to be rational.
Sure. So something that makes sense in the context of something that you're trying to accomplish. For example, let's say I've got hardwood floors and I don't want people slipping on those hardwood floors. So rationally, it would make sense that I don't want you, me, or anybody else pouring water or grease or oil or anything on these hardwood floors. I would think that rationally you would say, yeah, that makes sense.
No, that's all emotional. And you're
Why?
using reasoning to explain an emotional decision. Your fear is that if somebody slips on the floor and gets hurt, that they're going to get injured, and that may or may not lead to liability. So you have a fundamental fear of injury and or liability. You're explaining why you want to keep floors dry and clean as by justifying and explaining and rationalizing whatever rationalizing is by saying, I don't want the liability or I don't want people to get hurt. But fundamentally, what's driving the decision is not rationality, it's emotion. And this is something that many people don't get. Here's the thing, Parag. Neuroscience in the last 20 years has concluded without question and without debate that human beings are emotional beings, not rational beings. There is no such thing as rationality. Now, we do have critical thinking skills. We can use logic, quantitative, qualitative analysis, linear problem solving, scientific method. We got a whole bunch of techniques and tasks that we can use. We got algorithms. We got a ton of stuff that we can learn that allows us to solve problems and engage in strategic thinking and to analyze information. Those are tools, but they do not define human nature. So when the person comes up and says, gee, Doug, I listened to you talking about listening to emotions. How do I deal with the irrational person? I'll say to you, stop looking through the lens of rationality. Recognize that this person is an emotional being having an emotional moment. You can't solve emotional problems with logic and rationality. You can only solve emotional problems with emotional tools. So if you look at this person as simply having an emotion, being a normal human being with normal emotions, now all of a sudden we can bring a new tool set to bear on their feelings and the behaviors that result in those feelings that are effective. But as long as we think that people have to be rational, because that's human nature, then we completely miss the emotions and we only make things worse.
I'm with you. So if you're dealing with people, is it always an emotional type situation or is that then rational? So for example, if I'm building a table, I'm building a table with tools. That seems like it's a pretty rational thing. I would use certain kinds of tools because they make more sense to use than other kinds of tools. And maybe want to use a wrench over a hammer to screw in screws. Seems pretty rational. There shouldn't really be any emotion to that.
Okay.
But
so if you take a task like building a table is based on a whole bunch of algorithms, shortcuts and ways of problem solving, decision making. And so first of all, we have to make the decision to build the table and invest the time and effort to do that. That's an emotional decision.
mm-hmm.
Once we've made the decision, now we execute on the decision. The execution, for the most part, is just going to follow the algorithms that we've learned. Tape measure, square, cut, glue, joinders, Then we might get into along the way, emotional decisions around aesthetics. What kind of a joint do I want to use on this? How durable do I want this to be? How much time do I want to take building a table? How durable is this going to be? Those are all emotional questions. But the answer to those questions will then trigger an algorithm that will tell us how we're going to process and do the stuff. None of that is rational.
Mm-hmm.
It's making an emotional decision and then finding the algorithm that helps us execute on the decision that we've made. There's no rationality involved in that at all. You see, it's a very different mindset. And when I teach this stuff, this is the first mindset shift I tell people to make. There is no such thing as rationality. And when I began to do that, especially, of course, it took me a long time to realize all this, but I had been a peacemaker and mediator for a long time. And when I finally began to get these insights, all of a sudden, when I walked into a mediation and I saw people behaving, before I would say, that's just irrational. These people they're crazy. What are they thinking? Today, I'm saying, they're just being emotional. So let me walk into their emotions. Let me walk into that mess emotionally and help them sort it out at an emotional level. And when I do that, everything calms down, and people are able to fix their problems once their emotions have been de-escalated. I used to, in the early days, I'd have mediation that would go for 12 hours, 15 hours. Today, I rarely have a mediation that lasts more than 5 hours. And I don't care how much money's at stake.
Mm-hmm.
Because
Wow.
I recognize the emotionality, I deal with it. That frees people up people can solve their own problems once they get around the emotions.
Right. So, how does a listener use this, not from a mediation technique, but from a negotiation technique or a negotiation perspective, where they're looking to win on something or acquire something, as opposed to trying to force both sides to resolve a dispute?
A lot of it's going to depend on the type of negotiation. Is this a distributive negotiation or is this an integrative negotiation? In other words, are we arguing over positions, how much money is going to get paid, or are we trying to satisfy the underlying interest, needs, goals, and desires, which is called interest-based negotiation or integrative negotiation? Part of it's going to relate to the relationship you have with the people that you're negotiating with. Are you strangers, or do you have a relationship with them? Part of it is going to involve the stakes of the negotiation. How important is this? And all of those factors, again, those are all have valence, so they're all emotional. Every single one of those is an emotional process. Will dictate how you're going to approach the negotiation. If I want to negotiate with a 6-year-old who can be very stubborn and say no, then I'm going to approach that 6-year-old at a deeply emotional level. You're really upset. You're really frustrated. You don't feel heard. You don't feel like you're in control. Yeah. Okay, so what do we need to do to solve that problem? Or somebody could say, I want X. I want the top floor office, the corner office, and I want a new car. And I said, all right, if you got the top floor office, corner office, and you got the new car, what would be all the good things that would happen to you in life? So I get out of the position and start looking at the underlying interests that they want. Well, I want to be recognized, and I want to be seen as top dog, and I want to be rewarded for who I am, and I want people to know that I'm the top guy. So you're looking for validation, and you're looking for recognition, and right now you don't feel heard, you don't feel appreciated, you don't feel supported. Yeah. And what you want is to be validated, supported, appreciated, and recognized. Yeah. And you want it done in a way that is meaningful to you so that you feel like you've gotten your just desserts. Yeah. Okay. How do you think we should go about doing that?
Mm-hmm.
Notice how I moved away from the corner office and the car and got them into what they really want. And I've never used an I statement. Not one I.
You got them right. You got them into what they want based on the emotions. You got to the core, the deep reason
Correct.
as to why.
And that is a very fundamental negotiation strategy. Why?
Yeah.
I don't ask why, but tell me more about that. Tell me more about what are all the. Let's suppose you got what you wanted. What would be all the good things that would happen to you in your life? How would this change your life, and in what way?
And by them telling you that, they've told you what they value.
That's right. And now we get into a process of, okay, how can we satisfy your interests in a way that really has meaning, rather than your suggested solution, which is nothing more than your position. You're demanding $1 million, fine. That's just a position. It's just a recommended solution to the problem. But what really do you need? What are your real interest, needs, goals, and desires? And a lot of times, I mean, from crisis to justice, I love the name of your show. What people will say, I want $1,000,000. What they're really saying is, I want the sense of injustice that I'm experiencing to go away.
Mm.
And they're using money as a measurement of justice. The problem is, of course, that even if they win and they get a bucket of money, they still feel the injustice. Have you ever had this experience, Parag? You won this case. It was a tough case. You did it. You were brilliant, legally brilliant. You did an amazing job, got a far better result than anybody ever expected. And you walk out of the courtroom and the client's pissed at you and say, I'm not paying you. I just got what I was supposed to get in the first place.
Mm.
I don't know if you ever had that experience.
Oh, yeah.
I've had
Yeah,
that
I've had
experience
that.
too. And you're looking at yourself, man, I just burned up 60 hours a week for the last 10 weeks, put my body on the line for you, sacrificed my family life to get this incredible result, and you're not happy.
Mm-hmm.
You've seen that before, haven't you?
I felt that before.
Absolutely. And what's happened is that people have conflated winning in court with the sense that they're going to have a sense that they got some justice. And it doesn't happen. That's why I told people the legal system is not about justice. No court will ever guarantee you substantive justice. Do not expect the courts to be fair. Do not expect the process to be fair. Well, we hope it's going to be fair in certain ways, but don't expect the outcome to be a fair outcome. The outcome is a toss-up. It's a coin flip. We don't know what's going to happen. And there is no guarantee that the outcome is going to make you feel like you got a just result. And in fact, 9 times out of 10, you're going to feel like no matter what happens, it was an unjust result, because you're going to have to spend $500,000 in legal fees to get to the place where you think you should be. So you're never going to be made whole on this. You're never going to feel like there's justice. Never. And my job is not to deliver justice. My job is to prosecute your case in court and let a decision maker, either a judge or a jury, decide what should happen under the rules of law and the rules of evidence. And that's the end of it. It's just a decision. It has nothing to do with justice. Clients are shocked when you have that conversation with them.
That's a rough conversation, Doug. I will say that
you have to have it
the
with every
majority of the
client.
time.
You're crazy not to have that conversation.
Well, it's the rarity that that one-off client who's super upset at the end, who doesn't really believe that you really did as much as you did for them, that this was coming all along because this was the right thing, and they're just ungrateful for everything you've done. Those are luckily
you get those
rare.
You absolutely get those. Don't get me wrong. I'll just tell you a story, a war story of mine. My partner and I defended a very large company in a construction arbitration. And it was like a 4-week arbitration involving tens of millions of dollars. And we did the very best we could, and we had a pretty good case. But it wasn't a slam dunk. The arbitrators could decide any way they want. Before the hearing closed, we took our clients outside and said, is there anything that we haven't presented that we need to present? Are you satisfied with the way that we presented the evidence and the arguments you've made? And they all said, man, you guys were brilliant. Of course, we lost the case. And the client comes in, I'm so disappointed in you guys. You were crap. And we're not doing business with you anymore. You know, how do you respond to that? You just shake your head and say, man, you know, what they were looking for was something that couldn't be delivered. It was too many of those experiences that really drove me out of the practice of law. Saying there's
well, how would you deal with that now with the skill set you've got?
Well,
you've got a client
now
like that, what would you say?
I wouldn't set myself up as a trial lawyer to be in that position. I would be having these conversations with my client early on in the case. So what are you really looking for here? I said, your claim is going to be dependent upon 3 arbitrators under the construction rules of the American Arbitration Association. And it's going to be a beauty contest. And the other problem we have is that these arbitrators are dependent upon repeat players for their business. And the repeat players here are much bigger than you are. So there's going to be a bias going into the system. They're going to be more biased towards this massive company that has a lot of construction arbitration cases going all over the country. They're going to be automatically biased towards that party, unless you've got overwhelming evidence that where they're compelled to rule, even though they don't want to rule that way. And you don't have that kind of compelling evidence. You've got a case, but when you're looking at the bias of the system, it's not a bias that you're going to overcome. So what do you want? That's the kind of conversation you have to have, and you have to have that case discussion early on before you start spending a lot of money in discovery. And lawyers are afraid to have these conversations with their clients. I learned the hard way because I was afraid too. But,
well, it's a mixed bag. I've had the conversations with the clients. We always do that. Look, litigation's risky. There's no guarantees in litigation. Of course, juries or arbitrators or judges can come back some completely different way from what you expect. Sometimes it's really favorably, other times really unfavorably. So you don't know. You can control your odds to a certain extent, but you can't
exactly. And we all have that conversation. But I've learned over the years that when we have that conversation with the clients, they're not listening. They're discounting everything we say. It's called reactive devaluation. They believe their case. They've got all kinds of confirmation bias coming in, reactive devaluation, all kinds of cognitive biases are coming in, and they're discounting everything that you say. You say, yeah, but, that's what's going on in their head. Yeah, but not me. Yeah, but not me. Yeah, but not me. And they're not hearing you because they're emotionally invested in something, the case, but really the underlying emotions of the conflict. They've been betrayed, or they feel like they've suffered a deep and abiding injustice. And all of that underneath are emotional that are driving them to filter the information in a way that they discount everything that the lawyers say. Even if you put it in writing, which we all do, it doesn't matter.
That's true. Although there's then the risk that the client says, well, look, you don't believe in my case. I've had that come up where you tell them objectively, look, here are the issues, here are the challenges. Hey, you don't believe in my case. And then they'll just go hire somebody else. And that person's probably going to be worse off.
That's right.
They're probably going to be a worse lawyer for their case than you would have been.
So if a client comes to you and says, and you get them working, you say, you don't believe in my case. And you say, it's not my job to believe in your case. It's my job to take the evidence that we can marshal and put it into a judicially cognizable form so that it's admissible. And then from that evidence, argue that somebody owes you a lot of money. That's my job. I don't believe or disbelief has nothing to do with this. It has to do with...
That sounds cold.
What?
That sounds cold.
You have to be that way. And I'll do everything I can to do all that for you. But it's not about believing in you or believing in your case or thinking you've got some righteous cause here. That's all emotional. And cases are not about emotion. They are, but when you're analyzing what the situation is, we use ways of thinking that we're trained as lawyers to look at and anticipate how a judge or a jury might evaluate and weigh the facts. And it always comes down to emotion. But we want to try to tilt the emotions in our favor if we can, but recognize that at the end of the day, it could tilt the other way. And we can control how we present the evidence, but we can't control the actual decision. We cannot control the outcome.
Yeah. And what you're saying confirms a suspicion that I've long had, which is essentially people really do make emotional decisions, but they justify them with logic. So the decision is made, and then they, like juries, do the same thing.
Exactly right.
And so there's a whole theory of like the reptilian theory,
which is wrong. Don't you hear anybody you start talking about reptilian brain? Just stop listening to them. They don't know what they're talking about. I'll explain why. That goes back to the 1950s with a researcher at the National Institutes of Health, a guy by the name of Paul D. McLean. He was a neuroscientist studying brain. He was an early neuroscientist back in the 50s, and he came up with this theory called the triune brain theory. And what what his theory was the human brain evolved in 3 steps: the reptilian brain, the paleo-mammalian brain, and then the neo-mammalian brain. Because he saw, as he looked at animals, all kinds of vertebrae, he just saw this developmental process, and it looked to him like that's true. It turns out there is zero science to support any of that. And so, but it sticks because it's easy to understand. Oh yeah, reptilian brain, paleo-mammalian brain, neo-mammalian brain. Now it makes perfect sense to me. Believe me, the human brain is far more complex than that. And that is not the way that our brains evolved in the first place. But just like Freud, he came up with a kind of a simplistic, easy to understand thing that people could glom onto. Just like Freud was totally wrong. There's nothing that Freud said was ever correct. None of his work has ever been scientifically proven. But his thinking is still in pop psychology today. And the same thing with Paul MacLean. And his work was discredited in the 1960s, and yet we still hear this stuff. So whenever I hear somebody say reptilian brain, I say, you don't know what you're talking about, and I'm not going to listen to you anymore.
Yeah. So you agree with this idea that people make emotional decisions and then justify them with logic? Right. It sounds like.
Well, they try to justify or explain whether or not they use logic or not, because most people are really poor logicians. I mean, they don't know the difference between deductive and inductive logic. They mix and match standards. In deductive logic, the standard is it valid or invalid? Is the form valid or invalid? If it's valid, then that means the conclusion. If assuming the premises are correct, then the conclusion has to be correct, which is very narrow. And then in inductive reasoning, we measure an inductive argument by whether it's weak, moderate, or strong, and we're looking for the hundreds of logical fallacies that can be introduced into inductive reasoning that tend to make an argument weak or moderate. So most people don't know this stuff. They've never studied logic. And so they just use this sort of false lay idea of logic, which it's a tool, and they improperly apply the tools in their situations as a way of explaining why they have made the emotional decision that they've made.
Okay, yeah. And this is probably the last question.
I could talk about
is there a difference? Yeah, I could with you. I mean, I love this stuff. So let me ask you, is there a difference between rationality and logic then? Because if you're saying, look, there's no such thing as rationality, then that would also then have to mean that there's no such thing as logic. But it sounds like you...
Yeah, logic is a tool.
Right.
Rationality is not a tool.
I see.
If you really want to get technical, if there was such a thing as rationality, it would be an outcome that we could then, this is a rational outcome, that is a non-subjective outcome that can be objectively measured in some way to say this was rational as opposed to emotional. But we can't do that. We can use logic as a way of looking at information, facts, evidence, and we can use logic to help us understand, in the case of deductive logic, whether or not it's a valid argument. We're looking at the form of the argument. Or in the case of inductive logic, which is what we do as lawyers, whether we've got a strong, moderate, or weak argument based on the rules of logic that we learn. It's a tool like a hammer or a nail. Critical thinking, same thing. Scientific method, same thing. Qualitative, quantitative analysis, same thing. Linear problem solving, same thing. They're tools. They're tools that we learn. Learning algorithmic problem solving versus other kinds of problem solving, same thing. Algorithms, for example, learning how to count to 10. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. That's an algorithm. It's a set of rules. And we start learning the simple algorithms as children, and then as time goes on, we get more and more complex in our algorithmic thinking, but it is not rationality. These are tools for problem solving.
So, Doug, if people want to learn more about this, your work, how can they find you? How can they hear you talking more about this?
I got a YouTube channel. I got 2 YouTube channels, really. So you could go to you can Google, my YouTube channel is Douglas Noll, YouTube Douglas Noll, and the other one is The Power of Emotional Competency. So you can Google those. My website is Doug Noll, DougNoll.com, which has a huge amount of information of what we've been talking about today. And I'm a sole practitioner here in Central California. You can reach out to me. I answer all my own emails, Doug, D-O-U-G, at Doug Noll, DOUGNOLL.com. I answer all my own emails. I'm happy to chat with anybody about anything that I've been talking about. And I love the skeptics. So if you're skeptical about what I've been talking about today, bring it on. Let's talk about it.
Yeah, start a debate. So I love it. So to the listeners, thank you so much for joining me today. I mean, obviously, you can use many of these tools, if not all these tools that Doug has mentioned today, to effectively navigate your crises and turn them into justice. If you haven't already, make sure you subscribe so you know when the next episode drops and you can hear from incredible guests like Doug Noll to help you throughout your life, to help you with your business. So thanks again. And Doug, thank you again for joining today and sharing some of your hard-earned wisdom with us.